An employment judge has now ruled that the fear of catching COVID-19 is not a protected characteristic for the purposes of the Equality Act, when a woman claimed that she was discriminated against by her employer and refused to go into work during the pandemic for fear of catching COVID-19. So that's what I'm going to explain very briefly in this video. So welcome back. I'm the Black Belt Barrister, helping you to understand law. So many people have been afraid of going to work for fear of catching COVID-19, and some have wanted to stay at home. Some employers have opted for their staff to work at home. Other employers have opted that staff need to come in unless it conflicts with the up-to-date guidelines. But in this particular case, this lady refused to go into work and the employer therefore refused to pay her, and she said that she'd suffered a financial detriment as a result. In her claim, she said that this was discrimination on the grounds of belief in regard to coronavirus and the danger from it to public health. And this was at the time of the start of the second wave of COVID-19 and the huge increase of cases throughout the country. In the ruling, the employment judge said that he accepted that this woman had a genuine fear, but did not believe that it met the criteria for a philosophical belief that would be protected under the Equality Act 2010. Now, unfair discrimination is a common basis for a claim in an employment tribunal because the Equality Act 2010 sets out various protected characteristics which prohibit discrimination or unfair treatment based on one of these characteristics. This case discussed the elements of philosophical belief, among other things, and of course referred to previous cases. In the case, the claimant set out this belief as a philosophical belief, stating that my belief is a philosophical belief and it's genuinely held by myself. I believe it's important and forms a substantial aspect of human life and behaviour. Placing limitations on a person's right to manifest their religion or belief may amount to unlawful discrimination. This would usually amount to indirect discrimination. The claimant went on to say that she took the decision not to return to work, and the employer in turn said that they would not be paying her, and then her wages were withheld and suffered a financial detriment. She said that she claims this was discrimination on the grounds of the belief in regard to coronavirus and the danger that it posed to public health. In its analysis, the court looked at whether the fear of catching coronavirus amounts to a belief for the purposes of the Act. And paragraph 15 of the judgment reads, "I do not find that the claimant's fear amounts to a belief. Rather, it is a reaction to a threat of physical harm and the need to take steps to avoid or reduce that threat. Most, if not all people, instinctively react to perceived or real threats of physical harm in one way or another. It can also be described as a widely held opinion based on the present state of information available that taking certain steps, for example, attending a crowded place during the height of the current pandemic, would increase the risk of contracting COVID-19 and may therefore be dangerous. Few people may argue against that. However, a fear of physical harm and views about how best to reduce or avoid a risk of physical harm is not a belief for the purposes of Section 10 of the Equality Act, of course." Accordingly, the court reached the conclusion and said that the claimed belief does not meet the criteria and is not a philosophical belief within the purposes of Section 10 of the Equality Act 2010. So this, I suspect, is one of many judgments that are going to come out of various different claims and disputes, all related to coronavirus and the pandemic. So please make sure you subscribe for further updates. Give this video a like if you enjoy my content, and as always, thank you for watching.